Losing a loved one is one of life's most difficult experiences. In the midst of grief, handling their final affairs can feel overwhelming. If you are navigating this process in Connecticut, you will likely encounter the probate system. Today, we are exploring exactly what that entails. Specifically, we will break down the crucial role of the Connecticut probate judge, helping you understand what to expect as you honor your loved one's legacy. Losing a loved one is an incredibly difficult experience, but what happens to their home, bank accounts, and belongings after they pass away? This is where the legal process of probate begins. In Connecticut, probate is the official court-supervised procedure for administering a deceased person's estate and ensuring their final wishes are honored. Think of probate as a legal clearinghouse. When assets enter the system, the court steps in to manage them. The probate process oversees the collection of property, guarantees that any valid debts or final taxes are paid off, and ultimately distributes the remaining assets to the rightful heirs or beneficiaries. So why is this legal oversight necessary? Probate serves a few vital functions. It legally validates the deceased person's will, protects their assets from fraud, resolves complex debts, transfers ownership safely, and provides closure for the family during a challenging transition. At the heart of the probate process is the Connecticut probate judge. Far from just a ceremonial figurehead, the probate judge holds a crucial role in ensuring the orderly and lawful transfer of a deceased person's assets. Let us break down their primary responsibilities. First is will validation. When a loved one passes away, the probate judge must carefully examine their will to confirm it meets all of Connecticut's legal requirements. Once the will is deemed valid, the judge officially appoints an executor. If there is no will, they appoint an administrator to manage the estate. The judge also closely supervises the estate administration. They monitor the executor's progress to ensure debts are paid, taxes are filed, and assets are properly distributed. During this highly emotional time, conflicts can easily arise among heirs. The probate judge steps in to resolve these disputes, interpreting the law to provide fair and objective rulings. Beyond handling estates, Connecticut probate judges are fierce protectors of vulnerable individuals. They oversee the establishment of guardianships for minors, as well as conservatorships for adults who can no longer safely manage their own affairs. Finally, before an estate can be officially closed out, the judge meticulously reviews and approves the final financial accountings, ensuring every single penny has been handled correctly and transparently under the law. Connecticut features a unified probate court system designed to serve residents across the state. The state is divided into 54 distinct probate districts, ensuring a court is accessible to every community. These courts handle a wide variety of legal matters, far beyond just wills. Their jurisdiction includes overseeing decedents' estates, managing trusts, appointing guardianships, establishing conservatorships, processing name changes, and finalizing adoptions. When dealing with an estate, you must file in the correct court. Jurisdiction is determined by the town where the deceased person maintained their primary residence. You can easily locate the right district by visiting the official Connecticut Probate Court's website and searching based on the decedent's home address. The Connecticut probate process follows 8 key steps. First, filing the will. The executor submits the original will to the local probate court. Second, the application for probate formally requests the court to open the estate and appoint the executor. Third is notice to heirs and beneficiaries, informing all interested parties the estate is open. Fourth comes inventory and appraisal. Here, the executor identifies, secures, and values all estate assets, from real estate to personal jewelry. Step 5 covers the payment of debts and taxes. The executor must settle valid creditor claims and tax returns before any inheritance is paid. Step 6 is accounting, where a detailed financial ledger of all transactions is submitted to the judge. Seventh is the distribution of assets. The remaining estate is finally transferred to the rightful beneficiaries. Step 8 brings estate closure. The executor files a final return, the judge legally closes the case, and the executor's duties are complete. In Connecticut probate, the clock starts ticking immediately. You must file the original will as soon as possible. An inventory of estate assets is due within 2 months. Creditors have 150 days to file claims. The estate tax return is due in 6 months, and the final accounting within 1 year. These are general guidelines. Missing a deadline can cause severe delays or penalties, so always consult a qualified probate attorney to keep your estate on track. One of the most common questions about Connecticut probate is, how much will it cost? The total expense typically includes several elements. First are the court fees, which in Connecticut are calculated based on the estate's total value. You must also account for executor fees, attorney fees for legal guidance, and appraisal fees for real estate or valuables. While these expenses can add up, there are proven ways to minimize them. Proactive estate planning, like setting up living trusts, can help bypass probate entirely. For modest assets, Connecticut offers simplified small estate procedures. Finally, careful and organized administration keeps the process efficient, preventing unnecessary legal and accounting fees. In Connecticut, contesting a will usually comes down to 4 common grounds. Lack of testamentary capacity, meaning the deceased didn't fully understand what they were signing. Second, undue influence, where someone manipulated the deceased. Third is fraud, involving forged documents or deceit. And finally, improper execution, like missing witness signatures. If you suspect foul play, you must act fast. Connecticut has strict deadlines for contesting a will, so immediate legal consultation is critical. Navigating the Connecticut probate process can feel overwhelming, but you don't have to face it alone. Partnering with an experienced probate attorney provides crucial peace of mind. They will advise you of your rights, guide you through the system, prepare vital documents, represent you in court, and help minimize estate taxes and administrative costs. When choosing your attorney, look for experience, a solid reputation, and unwavering integrity to ensure a smooth resolution and protect your family's legacy. Let's tackle some frequently asked questions about Connecticut probate. First, how long does probate take? For simple estates, usually 6 to 12 months, but complex ones can take over a year. What if there is no will? Assets are distributed according to Connecticut intestacy laws. And what qualifies as a small estate? Estates valued at $40,000 or less can use a simplified process. Do all assets go through probate? No, things like life insurance and joint tenancy often bypass it. You can find forms on the Connecticut Judicial Branch website and tax details through the Department of Revenue Services. In summary, navigating Connecticut's probate system doesn't have to be overwhelming when you understand the probate judge's role. Remember, this video is for informational purposes only and does not constitute legal advice. Always consult with a qualified attorney for your specific situation. For more helpful resources and guidance, visit probateus.com today. Thank you for watching. Understanding Connecticut probate and the role of the probate judge can make a challenging time much easier for your family. If you found this helpful, please like this video, subscribe for more guidance, and leave your questions in the comments below. See you next time.